Blog Talk Radio.
Hello, everyone in the franchise world. My name is Paul Segreto, and this is Franchise Today. We continue week 7 of 8 of our 4th annual franchise legal series here on Franchise Today, and so far the series has been absolutely outstanding. We've had record live listenership and on-demand listenership, and we really appreciate everybody's loyalty. Certainly appreciate our guests throughout this series, because without their expertise and also willingness to dedicate time in preparation and also coming on the show, we wouldn't have much of a show without them. Last week, my guest was Lane Fisher from Fisher Zucker. We talked about financial performance representations. It was really a very interesting show. Today, my guest is Jonathan Redgrave. We'll be talking about eDiscovery. What is it? Why do I care? And next week, we'll wrap up our 4th annual legal series with Dean Heil from the International Franchise Association, who will be giving us a recap of the recently completed IFA Legal Symposium. Remind everybody that I was also a speaker at FranCamp last week, the IFA Marketing and Digital Marketing and Technology Conference, all about best practices. It was really a great event. I believe the presentations are now live on the Fran Social Network. If you cannot find them, please give me or reach out to me, and I'll be happy to direct you in the right, put you in the right direction. Last night, I was on Social Geek Radio as a guest with Deb Evans and A.K. Stout. We talked about FranCamp. That's also on Blog Talk Radio, so you might be able to find some more information there. Coming up events, we still are moving strong through the franchise conference time of year, it seems like, until we hit summer. In June, Franchise Foundry, the producer of the Franchise Today show, is a bronze sponsor in the Franchise Consumer Marketing Conference put on by Franchise Update Group, strategic partner of Franchise Today. That'll be in the Atlanta area as well. And I'll also be at the IFE, the International Franchise Expo in New York City in June as well. So really a lot of things going on, giving people a look ahead to Franchise Today. On June 6th, as we come out of the legal series, we'll be into our franchise model series. Ed Waller, the co-founder of CertaPro and the 2012 chair of the Franchise Consumer Marketing Conference, will be my guest, and we'll talk about consumer marketing. We'll follow it up on June 13th with operations and franchise relations. Recent Bonnie Levine Award winner Mary Thompson of Mr. Reuter and the Dwyer Group will be my guest. June 20th, we'll hit it hard for franchise sales and development. Robert Stidham, the CEO at Franchise Dynamics, will be my guest, and then we'll wrap up the franchise model series on June 27th. Amit Mitra, the CEO and founder of FranConnect, will be my guest as we discuss technology and franchising. And we're finalizing our lineup for the summer series, which is the Franchisor Spotlight Series. Again, it's all about best practices. It's non-promotional, and I think people will be very, very, very surprised. Just a great deal of information from the initial reports of talking, the initial feedback that I'm getting from my staff here as we're interviewing some of the potential guests for the summer. But we have had a commitment from Dina Dwyer-Owens on July 11th, so it should be a great show. And then, of course, September will be tied around the IFA's Public Affairs Conference. Month of September will be Public Affairs Month on Franchise Today. We also do a segment on franchising, giving back. Some exciting things going on there with the likes of what Jersey Mike's is doing, and certainly what the Dwyer Group is doing. And then hopefully in the next week or two, we can talk with Susan Blackbeth of Superwash, who had some interesting birthday wishes in the last couple of days, and they're donating or raising some money for a very charitable cause. So we'll be talking about that. October, November, of course, looking way ahead, we'll be focused in and around franchise sales and development as we wrap our arms around the Franchise Update Group's Leadership and Development Conference, as well as MFE Expo's West Coast Franchise Expo in Anaheim. So really a lot of information at Franchise Day. We're still on track to do 60 live shows this year, and it just wouldn't be the same, of course, without the great loyalty listenership that we've had this year. We've really taken it to new levels. Couldn't do it without our strategic partners, as I mentioned, Franchise Update Group, but also Brad and Sherry Fishman and the team at Fishman Public Relations, as well as Jeremy Leduc at Elements Local, our technology strategic partner. Today, before bringing on our special guest, Jonathan Redgrave, I have the honor of introducing Michael Kupfer from the Franchise Business Review to just give us a quick update of an upcoming franchisee event. Michael, welcome to Franchise Today.
Paul, thank you so much for having me on. We have a franchisee event coming up. It's called Frantopia 2013. It was basically created with the goal of bringing together franchisees from a wide variety of brands and industries, having them network and learn from each other at this event. So franchisees, as you know, often get a lot of help from their franchisors, both through annual conventions and other programs and mentoring programs and that sort of thing. So what we're really aiming to do is to complement those resources by enabling them to get some new perspectives on the issues they all face in running a small business by talking to each other and to some experts. So the event takes place in Chicago over 2 days, June 13th and 14th. It's going to feature a variety of speakers, including some current and former franchisees, and experts from some well-known franchise suppliers such as Bill.com, Listen360, and Fishman PR will be there as well. We'll be touching on topics such as how to get the most out of your franchise system, time management, finding an ROI in social media, things like that a lot of franchisees and all small business owners really have a difficult time really getting a grasp on and making sense of in their business. The bottom line is that we want to help them grow their business and increase their profits, and at the same time strengthen the franchisee-franchisor relationship. So for anyone that may be interested, I can be reached at michael@frantopia.com, or you can visit our event site, which is events.frantopia.com. There's no www there, just events.frantopia.com. And again, the event is just for franchisees, but I do encourage any franchisors to let some of their owners know about the event, especially any that might be in the Chicago area. It'd be really easy to get to and well worth their time.
Michael, I really appreciate it. I look forward to hearing more about the show. And, of course, my regards to Eric and Michelle and the team and Molly and the whole team up at Franchise Business Review. You guys do a great job. Thanks very much for being here today.
Thank you, Paul, and we appreciate your help as well.
Today we're talking about eDiscovery, and we're talking about specifically what is it and why do I care. And my special guest returning to our legal series is Jonathan Redgrave. Jonathan's a founding partner of Redgrave LLP. His extensive experience in all areas of complex litigation in both state and federal courts, and focuses his practice in the areas of information laws, which include electronic discovery, records and information management, as well as data protection and privacy issues. He has authored, co-authored, and edited numerous publications, including serving as editor-chief of the Sedona Principles, and speaks around the world on topics including broad cross-border discovery, information governance, privacy, data security, and emerging technologies. Just a very knowledgeable man in this very complex subject matter. Jonathan, welcome back to Franchise Today.
Oh, very glad to be here again, Paul.
Over the last few weeks, as we worked our way through the Franchise Legal Series, we had started off with Michael Lakehold from Plate Cook, and we talked about franchise sales best practices. And, of course, in doing so, we started talking about, some of the sharing of digital information in that process. The following week, Lee Plave, also from Plate Cook, was my guest, and we spoke about the digital world, protecting data, what to do with it, franchisors' responsibilities, and, of course, potential consequences. Barry Heller was on. We talked about franchisor litigation issues And, of course, we mentioned digital documents. Mark Hirsch was on, and we talked about franchise broker relationships. And, of course, we touched upon the sharing of digital information. Lane Fisher from Fisher Zucker was my guest last week, and we talked about financial performance representations and got real specific on some issues with respect to digital documents. And now we have you today, the digital document expert. You can't be without it, and yet so many people look at this topic and say, what? Literally, why should I care? So what do you say to that opening up, Jonathan?
Well, there's a lot of reasons why everyone needs to care about this. I think when we care about something, it doesn't mean that we get overwhelmed by it. That's the key here. But when people ask me why does eDiscovery matter, I kind of boil it down to three things: rules, numbers, and culture. The rules, and that's whenever you have a dispute, a civil dispute with another party, the rules in civil discovery say that not only documents, the paper things are in the game, but so is electronically stored information. And that's a recognition that 99% of everything today is generated digitally, and quite frankly, not that much is ever reduced to paper. Now, we still have a lot of paper out there, but of all the vast volumes of data, a lot of it is is born, and remains digital. Now, the numbers are really amazing when we talk about how much data there is in this universe out there. There's some great sites out there. Don't want to bore people with too many numbers. But when you think about the fact that, any given minute on the Internet, 204 million emails are going back and forth. But you look at Facebook, 6 million Facebook views a minute, or 2+ million search queries on Google per minute, 1.2 million video views per minute. It's just kind of staggering, these kind of volumes, but why does it really matter with respect to folks in this particular universe, in the franchising universe? Because the people who are doing these things on the Internet are interacting, almost all of them, at least within the United States, when they're looking for a product or a service. In almost every space you have the franchise relationship, the brand. Everything is out there that's being interacted through this. So you've got the rules, you've got numbers that are amazing. Then, of course, you've got the culture. And the culture for our world today involves social, it involves cloud, it involves mobile. So not only do we have all this data out there, we also have a significant amount of the world continuously interacting with that data world every minute. And so when they're looking for brands, when they're looking for maybe employment, when they're maybe looking for business opportunities, they want to see where they can go, what might be their career, what might be their way to build their family business. If they want to get into the franchise world, where are they going to go? They're going to go to their computer. They're going to go and find things on the Internet. They're going to go find what friends say on the Internet. They're going to go and look for background information on the Internet. So understanding this world is very important, because when it comes to actually having a dispute, that's where the evidence is going to be. So it's critically important that people understand that all of that's in the game, so to speak, and then to think about how they're going to deal with it.
Yeah, and certainly as platforms make the ease of use of communicating and researching information online, obviously it's going to get greater and greater. Last week, as I said, I was at the Digital Marketing and Technology Best Practices Conference and had the opportunity of listening to the editor of Wired magazine in the UK as he presented. And, of course, he talked a lot about mobile. And, of course, a lot of people think of mobile as just communicating by phone or just texting, and not realizing that it's really a mini computer. They're doing more and more search every day. I think the report was 37% of all search results are done off an iPhone by itself. I was surprised to hear the stat that there are more iPhones in the world than there are toothbrushes, as well as the fact that there will be 5 billion more iPhone users over the next 5 years than there are today. And you mentioned some very interesting and probably not so surprising statistics to you and I, but maybe to the general public at large, about all this use within the social media platforms. And you mentioned, I believe it was 1.1 or 1.2 million users on YouTube every hour. what I was surprised to find out that there's 72,000 new videos uploaded to YouTube every hour. So it's not just staying stagnant. I mean, there's just more and more. It's just exponentially growing. And, of course, with iPhones and tablets and netbooks and laptops. And, of course, we saw the whole thing at the conference about Google Glass. I mean, this is not going away. If anything, that might go away. Maybe it's going to be email and the traditional website, but those are different stories for another day. So let's talk social for a moment. You know, what does eDiscovery within social media really look like? I mean, what can specifically, you know, franchisors be looking at if they're presented with eDiscovery requests, and not really a request as much as it is a demand, right, for information that might have gone on within social media?
Yeah, let's break down social media for a couple of minutes here. And everyone understands what social media is. It's not just Facebook, of course. It's any number of other sites where you can collaborate, you can get together, you can share information, whether it's the Instagrams of the world, Facebooks, you know, microblog things like Twitter are kind of lumped in with social media as well. The law, of course, is something that's slow to respond. If you look in case law, see how many cases we're talking about Facebook or other sites, in fact, even MySpace, in the first part of the 2000s, you'd have a handful. But one vendor has tracked that there are about 689 published cases now, including social media from 2011 through 2010 and 2011. And in the first half of 2012, there was 320 just in that first 6 months of that year alone. So the pace is really increasing. I will confess that a number of those cases out there where you see them mentioned are divorce filings. Not really surprising, right? But what's interesting about this, when you think about the franchise world, and we all know this probably far too well, that when a relationship goes south or something doesn't work out, if a franchisee is perhaps not living up to the expectations and, more importantly, all the system requirements, it is sometimes just like a divorce. And so what can be said or what was said or what were the activities out there in cyberspace can often be very important with respect to understanding the dispute. Of course, far beyond that is what's happening to our brand. How is our brand being represented? Is it being properly represented? If you have franchisees that are using social to reach out, are any of the promotions being done properly in accordance with all federal, state, local laws that might apply depending on what that promotion is? And separate and apart from the actual operation in the franchise context, what are you saying? What reps, what statements are you making about performance, making sure you're not going beyond the proper scope of your public statements as to what you can and cannot say with respect to the franchise that you have. So that there's a lot of issues here with respect to the ins and outs, what you can and can't say in the social media space, both as the franchisor, but then also what are the rules of the road you've given, and then how do you know if people are violating that? Another realm here altogether is the employees of the world that are out there, whether they're employees of the franchisee or the franchisor has employees. What are they doing out there? How are you monitoring that? Can you monitor that? And the other part here is, are you doing brand monitoring such that issues do come up? How are you responding to that? How are you treating when people tweet about an issue at a store or a location, or they tweet about a service or a product? Are you keeping those as customer complaints? Are you managing those? Or are you having an outside firm manage those? Social media is a space that can be potentially amazingly powerful. And I will say that looking over the prior speakers here in this year's legal series, that people have been diligent. And if you haven't, obviously there's a great opportunity to go back and listen at your leisure to these recorded conversations. There's a wealth of very talented folks who have been on this show that have been identifying different issues and solutions. And I really encourage everyone listening to this to not stop with just listening to this program, but go and listen to the other ones in the series so far and think about what is the impact. And again, don't panic. Don't freeze up. It's just a matter of, like anything else you do in your business, be thoughtful. Be thoughtful about what your participation is in that space, what you're putting out there, making sure you're abiding by any legal restrictions on what you cannot say. being mindful about the impact and the need to know what others are saying about you. Your brand is critically important. You need to know how it's being represented. If others are, have the rights to represent about you as a franchisee may, but then what are the limits on that? And how do you monitor and police this to make sure the rules are being followed and you're protecting your brand? So social media is critically important. The lawsuits that deal with this, there's a lot of, well, how do I get access to these sites? Do I just go out to the Facebooks of the world? Typically, under the Stored Communications Act, the owners of the actual site content usually have to consent. You can rarely go to the provider and enforce it out of them if you actually have to get into the discovery there. With respect to sites that you own, you should have a plan and think about how you're maintaining historic copies if you need to, so you can actually, protect yourself if someone claims that the statements you were making were fraudulent, they're misleading, you were misguiding folks with respect to the franchise and its viability, et cetera, et cetera. You just have to be very careful and think to yourself, okay, a year from now, 15 months from now, 24 months from now, am I open to someone saying what we did in the social media space was misleading or fraudulent or worse? And we need to make sure that people can't come back and say we said things and we don't have a record of what we said, especially important on the franchise context. And so I think people just need to be mindful. Again, don't freeze up on this stuff. It shouldn't be that hard. It's just a matter of thinking before you do, so you don't have to do what some commentators have coined in the world of social media, instant regret. It's like, oh, why did I do that? And I think we could probably joke about, but we shouldn't, because this person should really have significant regret. A certain professional golfer, who's making off-the-cuff remarks that were particularly inappropriate. They were completely wrong, and you can't just laugh it away, okay? So instant regret, I think there's a deeper issue there with this person. We're not going to psychoanalyze him, but the issue is there that in a moment, one statement like that can damage a brand. And so for this particular professional golfer, he has a brand. And I am telling you right now that comment there, which then went viral across the world, it's going to damage his brand value, period. He will not recover, okay? And so, what happens to our brands as franchisors? What happens to our brands that we're out there? It's critically important that you don't let anything, you've got to guard that. And social media, again, is a great way to reach out to potential business relationships, great way for the brand to reach out to the consumer. But, don't take this lightly. It can really, really go south fast.
Yeah, definitely. Thank you for sharing your thoughts about that, especially about our listeners listening back at the other shows. I appreciate that. And certainly it should not be, this should not all be to the point of being totally overwhelmed, and certainly shouldn't be looked at as a way of, oh my God, if I've got to worry about this, I'm just not going to do it, because that's not a realistic position to take at this point. What we don't know, I was talking about this in a personal branding course that I was presenting this morning to some regional developers, is that, the thing with social media is we don't know what we don't know, meaning if your brand does not have it, a brand does not have a social media presence. What we don't know is how many consumers look for you on Facebook or Google Plus or whatever, don't find you, and go someplace else. We can't put an actual figure on that without trying to monitor everybody in the United States or the world. So we don't know what we don't know. What we do know, as I see commercials come across the screen and I see, a little tiny Facebook icon in the lower left-hand corner, big brands are realizing we at least need to have a presence out there, and then, of course, we need to build community, and conversation and discussion is very, very important. But, a lot of people, Jonathan, think, okay, great, they might be able to see this stuff on Twitter and Facebook, but, I deleted a lot of stuff. How does that, I think we need to get to the realistic notion of what can be asked for in eDiscovery with respect to social media, and what the franchisor's responsibility is in providing this information.
Well, anytime you actually have a lawsuit or you have reasonable anticipation of a lawsuit, and that's generally the standard. Reasonable anticipation meaning there's a credible probability that you're going to be sued, or it could be a government investigation. Then you need to take steps to preserve information. That is, you can't allow things to be automatically deleted. You can't have people ditching paper. If you have a records management policy that typically will delete or destroy documents or electronically stored information, you need to suspend that. And the reasoning is you want to have evidence available, and you don't want to have things that are making evidence not available for the ultimate trier of fact. So these duties to preserve crop up. Now, the point I made earlier, everyone understands that the rules are broad, and that means social media data is, depending on what the lawsuit or claim would be about, is in the game. So what happens is if you have this civil litigation situation, we're looking at what people think they need to retain in the ordinary course of business, is that if you have that situation, you need to make sure you are saving those posts. You're not taking steps to delete it and say, yeah, that was stupid, I'm going to get rid of it now. No, actually, then you're going to be charged with spoliation or worse. You've deliberately tried to keep evidence away from a court. That can lead to severe sanctions, both personally and on the company, including default judgment. You could have monetary sanctions. In the true worst-case scenarios, you get referred out to the Department of Justice or State Attorney General's office on obstruction of justice. You don't want to go there. So taking it very seriously is absolutely what you have to do if you have a litigation situation. Now, there are other situations, right, where you have people have complained about a posting, or you look at a posting and say, no, we didn't get that right. A business shouldn't be forced to continually transmit or say things that they determine are not the best way or not an appropriate statement. And so in those circumstances, do people take things down? Yes. What is interesting is, do you have a process by which you, when you take down posts or other things, to keep an archive of that? And I think that's a risk question that the organization needs to say, are we going to have to defend what we did, both the initial decision to put things up and then the subsequent decision to take it down? And many times you're better off by having a record created that says, this is why we took it down. We were being a responsible corporate entity. We determined that was either not appropriate because it didn't have all the facts in it, or it created a false light, or whatever it is, that there might be documentation against. This is kind of where you really do get the lawyers involved to understand the best way to do that. But to have thought through in advance what we're going to do is a matter of process, to make sure we don't lay ourselves out there that other people who captured it can raise questions, and we have no record about what we did or why we did it. So there's a lot of issues with respect to the world of social, because that instant regret, constant comment is out there, that there's risks that, once said in cyberspace, it never disappears. There's a lot to that. So even if you think you've deleted it or taken it down, other people might have taken a screenshot. They might have been able to save it to their computer some other way, cut and paste pieces of it, any sort of other data capture they might have done. So just because you take it down, you can't assume that you've really eliminated it from the web. There's just actually no such thing as truly getting it out there and then taking it back. It's like a sound in the woods. You make a sound, there are people there that are going to hear it. You can't unring the bell.
So if a franchisor is being sued and there's an arbitrarily or just this blanket request to provide, all e-documents and communications, all digital documents and communications, what does that actually mean to a franchisor? What's realistic?
Well, like any case, you're going to see lots of people that are going to both write letters to you, and people are going to say you need to produce all electronic documents, all electronically stored information. And anytime send something to me that says produce all, it's just a red flag. And in fact, the rules are beginning to move towards a change where that's just going to be absolutely verboten. You can't just ask for all. It's silly. It's dumb. It's not focused. It's not proportional. So what I would suggest, and what most good lawyers will do, is you'll actually maybe even pick up a phone before the responses, or with the responses you'll encourage a dialogue. This is where people talk about the meet and confer sessions in federal court, but a number of states are beginning to move that way too. You want to have a dialogue with the other side about what do you really need, and we expect the social getting down to what's the nub of the dispute. Is it a about something that we said with respect to the finances? Was it something that we said with respect to the quality of the product or the service? Was it something with respect to the, you name it, the support for franchisees? Let's get down to what the issue is and then determine what you have. Determine immediately if there's anything that seems to be within that scope of what really is important in a case. In other words, what's relevant. Then make sure that you're not deleting or destroying that information while you figure out what within that world of relevance you're going to take out. And I mention relevance because you don't get in trouble for deleting or destroying things that aren't relevant. If they don't have any bearing on the case, then there's not an issue or a problem. The difficulty comes in understanding what the case is about, if it's really vague, or understanding if the requests are really within the scope of what the case is. And that's, again, don't taking your chances in just kind of like fighting a letter battle or, the discovery response against the request and then just running to court. Courts have a hard time with this stuff, and understandably so. The courts across the country, especially state courts, are strapped for cash. You're talking about in California courts, for example, the average time for a civil trial has increased by an entire year. The old discovery referees that they had in most of the courts are gone. You have a complete, gutting of a system with respect to clerks and others. It makes it very difficult for civil matters to get through that system anywhere close to what it once was. Other states are having similar issues, but quite frankly, even on the federal level, we've got a number of vacancies that are still out there. The Senate is very slow to go through the process. The confirmation the president actually hasn't nominated as many as he could. So the judiciary deals with the criminal aspects of the world. They deal with family law issues of the world, depending on what system you're in. And I think people have to be really mindful about not thinking that they're going to suddenly be able to jump in and whiz-bang figure out the limits and scopes of discovery of any type. But certainly when you start getting into more complex areas of electronic discovery, when you start sorting through, well, where's the social media going? And almost always, I think parties are best served by having an effective advocate that understands this stuff, but is looking to negotiate with the other side to find the best deal, so to speak, with respect to contours of discovery. And then you find that stuff, and you produce that, and you move on with it. Because let's face it, we don't need armies of lawyers. You shouldn't have armies of lawyers getting involved in most of these disputes, because you're not talking about hundreds of millions of dollars. A lot of the disputes are far more manageable in terms of an actual exposure or dollar number for the dispute. And what that really dictates is proportionality. Says you shouldn't be spending, if you had a $75,000 case, or let's say a $300,000 case, you shouldn't be spending in a $300,000 case, $150,000 on discovery. That's insane. It's like a divorce. I'll go back to divorces, where everyone's fighting over the velvet picture of Elvis, and as they fight over things, the entire corpus of the family trust disappears. I mean, people who are in this space, I think, especially on the franchise side, the business people, they have a good sense of numbers, and hopefully most of the people on the other side have a good sense of numbers, and people can figure out ways to agree, not just on the ultimate. 95% of cases settle, folks. There's a reason why. But then the reality is on discovery, what's going to have the same common sense, calm-headed, rational approach, so we're not just beating each other up for no good purpose. Now, I say that, I'm a little bit Pollyannish. I've been influenced by the Sedona Conference's cooperation proclamation. I'm a member of Sedona. I just believe it's a better way of doing this, because I've seen far too many fights in my 20-plus years out there practicing. I've seen far too many fights that you really say to yourself, what was the point of that? And so when we get back to your question with respect to social media, it's very important that you just don't take that request and say, really get to what that case is about. Reach out, negotiate. And if they're not willing to, make sure you're the most reasonable person in that forum to explain why it is what you're offering to produce really is the scope of the case, what is relevant, and why everything else is outside of it. It's going to cost too much. It makes no sense. It's not getting us any closer to a resolution. And if you're putting in some burden arguments there, make sure you have real facts. Don't just say it. Courts are not going to take your word and say, it's really hard. They're not sure. They don't know. But a lot of judges have learned this, that most lawyers are not technical. Most lawyers don't know this either. So show me the facts. Show me the facts, and then we'll make a decision. So don't forget, that's a critically important thing here. If people are asking for, and the lawyers are going to make arguments, that we have real facts to back up any burden arguments we're making, and then, whether it's with respect to the scope of where the information is, make sure someone who understands the transaction or the issue can really make a credible determination that what is being asked is outside the scope of relevance.
Well, certainly we're all about facts here on Franchise Today. We're live today. My guest is Jonathan Redgrave with Redgrave LLP, an information law firm. And we're talking today about eDiscovery. What is it, and why should I care? Jonathan, real quick, and then we'll move on to a next question that I have. But one question that came up as I was starting to think about, Facebook and Twitter and LinkedIn. Where do subpoenas of these platforms fall into play? I mean, is that something that is realistic? I mean, can Facebook be subpoenaed to turn over a brand or an individual's Facebook records?
Well, a couple different layers there. Generally, in civil litigation, you're not going to get very far subpoenaing Facebook because they're going to point to the Stored Communication Act. They're going to point to other things to say, you know what, you need to go to the individual who owns that site, if it's a business, or certainly as a personal individual, but usually every account has to have a real person associated with it. And so they really don't want to be in that business. Now, if it's a criminal subpoena or, actually national security kind of stuff you never hear about, well, the government can get in there and do things. But in normal civil context, those sites really want to protect and guard against them becoming the purveyors, the presenters, and the providers of all information about their customers, their clients, to the rest of the world. So they zealously guard, and each of them do have response factories for, the many people that still nonetheless subpoena them. You're much better off subpoenaing the person who has the control over the information, the account owner. So if you have to go after someone, you put it on them. If they refuse to give the access that you can get the information, they refuse to give a permission such that Facebook will make it available, or if they refuse to provide it directly to you, then your beef is going to be with them. In a subpoena context, you're going to have to bring a motion, and you're going to say they didn't properly respond to Rule 45 subpoena on them. If it's the adverse party, of course, you get the party discovery options, their failure to respond, failure to make the information available. Now, what's really important is that if you believe the relevant information you need is out there in social media, you do your best to find the publicly available information that you have. Like, if they posted a flyer in the middle of the street and you can pick it up, that's fair game. So if it's publicly available out there, that's one thing. If you know from that publicly available information or elsewise that there are other sites, there's other information out there and you have no access to it, you put in a discovery request, and if they stonewall you, they refuse to deal with it, then you go to the court and you explain again. You're not just asking for everything. No, never do that. Ask for what matters and be able to explain to the court why it matters for you to get access to the social media postings, for the understanding what they've been saying, if they've been saying false defamatory stuff about you or about others involved with the franchise, or things that have been damaging to the brand. There's all sorts of things that could be said that could be relevant information depending on what the dispute is. But I think it's just critically important to realize that as it goes, trying to just say, we'll just run to Facebook and have them do a search for blank or this or that. No, that's just not going to be a very viable first option for you.
Yeah, and of course, as more and more of these social media platforms are entered into Google search results, obviously a lot of that information can be found through search results and alerts and what have you. And of course, if you're faced with something like this, I mean, you could be considered to be in some stormy weather. And of course, as we know all too well, storms have a lot of clouds, and of course, we have the cloud to talk about with respect to backup and storage. So where does the cloud come into play in the whole eDiscovery process?
Well, a couple things about the cloud. The cloud, again, like most things, you don't have a knee-jerk reaction and be afraid of it. The cloud, and I think most entrepreneurs realize this, is a great leveling power, right? That it gives massive computing storage, massive computing power to the masses that we can, depending on the scale of our enterprise and what we're trying to do, we can really leverage it. And it's elastic. It responds to our needs and our demands. But with respect to the data, there's some basic considerations that we should think about when they're just in the cloud as a matter of business. And first of all, do you know who your cloud provider is? Do you really have confidence in their sustainability as a business organization? Have you done your due diligence? It's just like if you gave some of your most important assets to someone who's going to park it in the warehouse. Do you really know that they have locks on it? Do they really keep it secure? The concern gets amped up, so to speak, depending on what information you've got out there. Is it information about the franchisees? Is it information about the franchisees' employees? Is it information about all of the different customers of the brand that are out there? Or have you collected, or does it reflect personal identifiable information? You suddenly get into all these issues about, I know if we had the data in our server, it would be secure, but we've given it to this cloud provider. Well, what do you really know about that cloud provider in terms of how they're, managing the data? How do they manage the access? Do you know anything about that? And these are just some basic things that we'll get to the legal discovery part of it. It's very, very important to think about what we know in terms of the data storage, data locations, data accessibility. Now, beyond that, a lot of people think, once it's in the cloud, it's secure there. Not necessarily. Again, back to how sustainable the organization is. What are your rights in case the company goes out of business? Are they going to get you the information? Do you have a backup that's not dependent on that one cloud provider that you could get to in case there's a service interruption or the business went under? Here's another thing, too. You want to move from one cloud platform to another. You're looking at different things. Did you negotiate the ability to demand your data be transferred from one to another? Another thing with respect to the cloud, have you migrate or have you separated, let's say, all different franchisees in your system? Are you going to allow them to store stuff separately? You're making a cloud platform available to them. Are you actually paying for that? Are you integrating the data so there's just one data source that different people have access to? Or does everyone have their own silos, so to speak, within the cloud space that you might be providing? Very important, as that might come down to, who actually has access to it for a dispute? Who has possession, custody, or control? Now, I said those words very slowly. That's really the test of whether or not you have a responsibility to preserve and produce information. If you have possession, custody, or control over it, you may have a duty, depending if it's relevant in the case, to take action to both preserve and produce it. So whose data is really in the cloud, who really owns it? Very, very important things to think about in the business relationship in the first place. Other issues with respect to the cloud, when you have a dispute, you need information. Is there some service level agreement or SLA with respect to the cloud provider responding to you? They're actually going to know this a legal discovery matter, that they, as your agent, are going to take the right steps to preserve information rather than letting it just roll off their servers. Are they actually saving it? Are they able to produce it to you in a timely manner so you do not get in trouble with respect to a court that you said, we asked for it from our cloud provider, but, they haven't given it to us in 2 months, so sorry, Judge. Well, sorry, Judge, isn't going to cut it. The judge will say you blew your deadline, so there will be severe consequences for it. So think ahead. Do you have provisions in there about how you can request and ensure that your cloud providers are preserving information if needed, and they'll actually be able to pull it out and provide it to you if there's a legal discovery event? So the cloud is this amazingly powerful thing. It's a great thing, but the cloud, just like social media, it's in the game for discovery. Understand what you're doing in the cloud from the standpoint of business, protecting your data, securing your data, but also think about discovery. What will you do if there's a discovery event? Will my cloud provider be able to preserve it? And will they be able to give me the information I need when I need it for a lawsuit? Now, again, don't freeze up. It's just something that you need to make sure you think about now. It's the old Boy Scout motto, be prepared.
Yeah, well said. And, of course, we know the clouds are in the sky, and the sky could be looked at as the limit here. But, of course, when we start looking at the airwaves, we look at mobile technology, cell phone towers, satellites, and what have you, obviously well beyond the sky. Where does mobile play into the whole eDiscovery mix?
Mobile is another great area, right? We've unshackled ourselves from the desktop and from wires, and we've gone far beyond the initial BlackBerries. We've got so many amazing apps that we can have out there. We've got apps that we roll out that allow people to understand and interact with our brands, right? They do all sorts of things to understand where our store locations are, what the hours of service are, different permutations of what the product or service are. But then beyond that, we've got employees that use mobile devices all the time with respect to work scheduling, with respect to understanding perhaps different parameters of what the job functionality is, or down to the fact that we have mobile devices that we use to monitor. Maybe we're doing our store or site inspections. Maybe we're doing all sorts of other things where we're going to be capturing that with respect to the device, both in terms of maybe pictures, in terms of data, in terms of other things. There's all sorts of ways in which you can download data from any of the locations in any of the devices there that have data storage into the mobile device, where you have people doing audits or other analysis. So suddenly you've got an amazing ability to quickly go from place to place. You've got this mobile device that has all sorts of different apps. You're also then texting on the device as well as maybe doing the email. You've got voice information that might be saved on the device. And you've got, of course, other system-type information, whether it's about the number of calls, call logs. Each device has an amazing amount of data on it now. And then there's some complication, of course, because whether you're using a Samsung, an Apple iOS device, you've got, any like Samsung's in an Android world, but you've got the BlackBerry world with the new Q and the Z10s coming out. And even within the Android world, depending on the device manufacturer, it stores data different ways. There's some complexities when you actually get into the forensic side of this, pulling data out, finding it, and what do you really need? What are you really going to do with it? Are you just looking for text messaging? Are you looking for the downloaded documents? Or are you looking for the photos? You took photos of a site or an incident. Well, you know what? That can be evidence. So mobile devices are extraordinarily powerful. In terms of understanding if you have employees or other people out there that you provided the apps to, how are you managing the security of the device? Are you ensuring it's all encrypted data? Are you also, for that matter, having mobile device management that if it goes missing, if it's lost or stolen, and it's got critical information about the store, the franchise, the brand, financial, otherwise, personal information, you have the ability to remote wipe it, remote destruction, having been backing it up. All sorts of questions that are out there just, again, in the ordinary course, but guess what? This show's about eDiscovery. And you say, okay, mobile, big, mobile, great opportunities, mobile, potential risks. What do I do in discovery? Well, just like everything else, I hope you hear the consistent theme, not to scare you, but to prepare you. The consistent theme is it's in the game. So we're seeing more cases where people are talking about, okay, did you collect from the computers? Did you collect from the databases? Did you collect from paper files? And did you collect from the mobile devices? The typical response in most cases has been, and it's typically true for a lot of corporations, big corporations, that the data on mobile devices have been synced to the network. And sometimes that's just because it was email, and other times because they used a service, an AirWatch, a Good for Enterprise or something like that as a mobile device management that actually locked out or made sure that the data being used for business was replicated on their server. Well, the truth is, as you go further down the food chain from the Fortune 1, 15, 30, 50 kind of companies that have that kind of infrastructure and control, that a lot more people are just leveraging the benefits of mobile with maybe not having as secure or as stringent, I should say. Not to say it's not secure, not as stringent kind of mobile device management. They're not trying to force out this kind of copying, which then makes it more likely that there's unique data floating around on the mobile devices. Now, I think, truthfully, across all enterprises, we've really got to be mindful of the fact there's a lot of data that could be on these devices depending on the apps that you authorize, or if you don't control apps, as many apps as you can find in the App Store, people have those apps on there. Question, are they using them for business? So I think one of the first things you have to do if you have a lawsuit, you have to talk to all your people involved in that lawsuit. Let's say there are 5 employees at your company, and those 5 people all have mobile devices. You need maybe ask them, okay, what do you use your mobile device for business? Don't assume that they just used the laptop computer and they didn't use the mobile device. You can't assume that. If you've got a smartphone, if you've got iPads rolling around, you've got any of the tablets rolling around, you need to ask, what have these devices been used for? And then to determine if there's any unique data that's relevant on those devices. And unique data, again, you don't necessarily have to copy and collect 5 different copies of the same thing. If you've got an authenticated source in the server or in the laptop, you'll need the same exact thing that might appear on another device. But if it's unique data, you need to at least know that. You need to know what your people are doing. So from the legal perspective, you don't blindly assume anything. You should never do that. But certainly today, we want people to have open eyes and say, how are mobile devices being used? As a franchise, if we're doing audits, we're doing controls, we're doing other things, are we using mobile devices? Are we using special apps that we've actually put together ourselves? What are we doing with the apps? And understanding what data is generated on those mobile devices that we might have to collect. This, again, is in the game. Be prepared. Know what's the potential. Don't be scared.
Yeah, definitely don't be scared. And I think something that resonates loud and clear with me in a lot of these issues is, exhibit some common sense. Take a moment before you click that button, press that key, whatever the case might be. Think about it long and hard before you send it out, because you can't undo that. You can't put the toothpaste back in the tube in these situations. And I've seen that all too well with somebody that's, sent out a message on social media or an email or whatever, and, of course, regrets it the first time they go back and reread it and say, should have never said that. I should have never done that. So, thank you, some good common sense there. So as we focus specifically on the franchise world, what is there in the franchise world that complicates the issues that you've just identified for us, whether it be social media, the cloud, or mobile?
I'm not sure if it's necessarily a complication or just additional challenges or additional things people should think about. So one of the things I would say, and this is especially kind of a new thought for anyone in contractual relationships, but I would like to think that people in the franchise world should consider this, and that is, what are your contractual dispute resolution provisions? Are you putting in alternative dispute, ADR-type provisions in there if there is an issue? And oftentimes people would do that, but they don't really go further. You can contract for anything. So one thing I would say is, have you thought about trying to cabin what the scope of discovery is? Limiting. There are ways in which to do it. I wrote a law review article with Jay Broods, who's now with the Drinker Biddle firm, and we had that published. And it was, I think an idea for people to consider are the ways to contractually agree upon what the scope of discovery is so this get out of control. With respect to understanding this electronic data world for franchises, there's a huge thing that depends on what the dispute is about. If it's an issue downstream of the brand where you have maybe employees involved or the public, what is your response plan with respect to what you need to know to be able to respond to the event? Are you going to need third-party subpoenas against the employees of a franchisee? Or are you going to have direct discovery against the franchise? But more complicating than that is, okay, let's say we have a common data platform in the cloud. Was there any separation of this? Do I have the direct right of access, and is that impacted by any contractual provisions if there is a dispute? Do they have the ability to get into that data and find out things about me? Or about this system as a whole during the midst of that? Do we deal with that in the contracting stage? What are our access rights and controls if there is a dispute? And there's a lot of complications here when we're actually now leveraging the cloud to provide everyone within the system a lot of access to data. We need to understand that. Of course, it's not just about security controls, but ultimate access and use controls. And the reality, if we have disputes, what are we actually going to do? Now, an interesting complicating factor here, too, is just like any system, if you have individual owners of the franchises out there that are representing your brands, they get into disputes with other people. The franchise itself, the franchisor, is not involved. But guess what? Those other people come trotting to you and say, you must have access to the data. You need to go and produce it. They serve a Rule 45 subpoena on you and say, pony up. And so then the big question becomes, what was the contract. What rights of possession, custody, or control do you actually have now by virtue of the way in which you set up the system, the cloud, or which you set up a database system or some sort of communication system? If you set that up in such a way that you have either possession, custody, or control, and remember, control is just that legal right to get into it. You have a legal right. You said, on demand, I can go and grab this. Well, guess what? That third-party subpoena, of course, is going to say, hey, you can go do it. Go do it. And it's kind of like you'd be saying, well, wait, no, it's not fair. I mean, those are the two parties in dispute. Why are you coming to me? They're coming to you because you're going to have more money. They're coming to you because I think they can force you to do things maybe they can't force someone else to do just as a matter of practicality. Now, a court can order anyone to do things. But you got to understand when you're setting up these systems that there might be a downstream consequence that people are going to find that you have possession, custody, or control over the information. It's just something to think about. What does that mean? You don't do it? Not necessarily, but realize there's going to be a consequence. You might have to answer up and pony up things. Now, within the agreement, you might try to shift costs. In any court dispute, you might say, we'll do it, but Rule 45 gives us more protection, blah, blah, blah. But again, depending on the volume and depending on the complexity, it could be a very, very expensive event for you to have to respond in that circumstance. So I think the possession, custody, and control is a big thing. I think understanding how you set up the franchise relationships, if there's some way you can contract out or deal with the discovery in advance, and then what is your response protocols, both for your first party, if you're either bringing the suit or responding, you're going to have discovery, how are you going to respond to that, and then what's that third party world look like, and then think to yourself to make sure that in this world, you understood how you're dealing with your mobile devices. You're understanding how you've dealt with social. Okay? So in both of those contexts where information that relates to the business, relates to your business relationships with franchisees, how it relates to your employees, and most importantly, of course, how your brand relates to the public.
Yes, I yesterday I was presenting at a webinar with Elements Local on online marketing, and we were talking about search, and we were talking about mobile, we were talking about SEO, we were talking about responsive websites and what have you. And it all came back down to having a strategy going into each of those. And certainly as part of the utilizing mobile devices, there needs to, and social media and everything else, there needs to be, strategies in place, guidelines and processes in place as you launch these things or as soon thereafter as possible. I think my word of advice, and I'm sure you would concur without me putting words in your mouth, is that, don't do this, a couple of years down the road, because then it will seem like an insurmountable task. It certainly would be considered overwhelming at that point. Jonathan, we have a couple of minutes left. If you could give some parting advice as to what franchisors can do to protect themselves moving forward in this ever-changing and expanding digital world.
Well, I think you kind of touched on it right there, and that is just like weight loss and anything else, right? You add weight, a couple of pounds here or there, and suddenly you find yourself having to really work hard to get back down. Understanding the importance of the social, the digital world to every franchise is critical. If people here listening to this radio show aren't surprised by that. Actually getting a good, personal trainer in the physical space could be awesome. They're not going to exercise for you, but they're going to help you. I think in the same way, thinking about getting good guidance, from the business side and from the legal side, that people understand. There's some rules of the road here. There's some conscious here. Make sure that our digital footprint is complying with any legal requirements on it, but it also makes sense from a business standpoint about how we've posted the data, how we're controlling the data, how we're accessing the data, how we rolled out mobile devices for our employees, how franchises might be using it, how we're using the social space to connect, and how we can actually protect that brand. Come back to brand protection principles when we're talking about how do we make sure that how our digital footprint interacts with the world, we can protect the brand. And again, I think litigation response readiness programs, we have people come in and kick some tires. It costs a little bit of money, but you might be very well off because someone's come in and said, you have no protection here. Have you thought about this in your agreements? Have you thought about doing this as a protocol for response Do you have a way in which you understand how people are rolling these things out? So you have a good understanding of the risk profile, and then you can take, common sense, practical, economically viable approaches for different things. And some of it might be policy, some of it might be imposition of different technologies to limit access, some of it might be just getting a third-party service to examine or monitor certain things, and none of which has to be bankrupting at all. But it's just like insurance, right? It's a good investment. It's a good thing to do. So be smart in this area. Be prepared. Be willing to take a good look at what you're doing to make sure, 10 years down the road or 10 months down the road, you don't say, oh my, we never thought of this, we didn't take care of this, and now you're trying to bail out. You don't want to do that. Again, Boy Scout motto, be prepared. The digital footprint for a franchise, for a brand, is critically important because you're exposed. Take care of that. Insure yourself. Just do the smart things to know where you are, and don't panic about this stuff. We've had an hour-long program here. It's really been about some issue spotting, kind of talking about the courts are really attentive to this stuff. But again, don't panic. Take some time to look at your footprint and give yourself a good health check.
Absolutely great advice, Jonathan. I really appreciate you being back with us on Franchise Today. I look forward to having you back on the show in the future.
Happy to be here. Happy to talk with everyone. Have a great day.
Next week, my guest is Dean Heil with the IFA. We'll be doing a legal symposium recap as we conclude our 4th annual Franchise Legal Series on Franchise Today. Until then, my name is Paul Segreto, wishing you the best, the very best in this great thing we call franchising. Franchise Today is out.
When you're part of a military family, you understand sacrifice and support. So at American Public University, we honor your dedication by extending our military tuition savings to your extended family. Parents, spouses, legal partners, siblings, and dependents all qualify for APU's preferred military rate of just $250 per credit hour for undergraduate and master's level programs. American Public University. Value for the whole family. Learn more at apu.apus.edu/military.